My name is Ellen Zwarnstein. I am the coordinator from the state of Michigan. Your judges will introduce yourselves and they'll ask you to introduce yourselves as well. And then we will begin with the prepared remarks. I will be holding up time cards, just verify that you can see that all right. And we'll be good to go. Have a wonderful hearing.
Thank you.
Thank you.
Good afternoon. My name is Barry Anderson. I'm an Associate Justice on the Minnesota Supreme Court. I've held that position for a number of years now. I'm the Senior Justice on the court. That and $10 will buy you coffee somewhere. I have some experience with this program that predates my arrival here as a judge. Many years ago, I was an assistant coach on a team from Minnesota, and I have some idea of the stress you're under. I just want to assure you we're looking forward to our conversation. I think it's going to be great. Judge Zinkin?
Yeah, it looks like my video has stopped, but hopefully you can hear me.
Mm-hmm.
Okay, good. So I'm Ann Zinkin. I am a career law clerk at the New Hampshire Supreme Court. I've been here for about 21 years. And prior to that, I litigated employment law cases in San Francisco for about 12. And I've been doing the We the People competition at the state level as a judge for somewhere between 5 and 10 years. I just can't remember how many years, but I'm very excited to participate in this conversation with you.
Hank Chambers, a law professor down here at the University of Richmond. And I've been at this We the People thing since before you all were born. So, and I like the fact that your teacher, it looks like he's Massachusetts' wild teacher. So that's just fabulous.
That's the way to be, Hank. We got it. We got to be wild. It is great. It is great to see all three of you, and we're excited to be here today.
Fabulous.
Very good. If you'd be so kind to introduce your team and coaches and assistant coaches and whatever.
Hi, I'm Lily Dardno. I'm a junior.
Hi, I'm Walter Solzak.
Hi, I'm Daniel McKiernan.
And I'm Megan Alvarado, and this is our teacher, Mr. Gunn.
Very good. Well, we're here to discuss Unit 4, and the question that we've been asked to interrogate you about and listen to your statement concerning is question 1. It would be inconsistent with the constitutional separation of the executive and legislative powers to let the prerogative or pardon power be exercised by the latter. What were the framers' reasons for giving the president the pardon power, and do you agree or disagree with those reasons? According to framer James Wilson, if the president abuses the pardon power, he can be impeached and prosecuted. Do you agree with Wilson? Why or why not? In your opinion, what constitutes a high crime or misdemeanor? We're looking forward to our discussion today, and you may begin when ready.
The presidential pardon power is one of the most controversial powers the executive holds. Historically, it had been a highly abused power by Stuart monarchs, which gave many of the framers concerns about the presidential exercise of this power. The framers shared a common fear regarding granting the pardon power to the president. Nonetheless, it was decided that this was a vital power, yet the threat of impeachment was created to curb the abuse of the pardon power.
The framers thought the pardon was vital because it is a way to balance the judiciary. They committed to creating a system of powers that were separated, yet also connected to ensure there was a proper use of checks and balances. The framers decided that thus the abuse of the pardon can be interpreted as a high crime or misdemeanor, therefore giving Congress the power to impeach the president.
Framers, especially Hamilton, believed the executive should hold the power to pardon. Hamilton explained in Federalist 74 that one man appears to be a more eligible dispenser of the mercy of government than a body of men. They thought if the power was held in the legislature, Congress would be too messy and not effectively use the pardon. So they gave the pardon power to the executive rather than the legislature.
The framers rightly placed the pardon power in the hands of the executive because it is easier to limit the powers of one man than it is a body of men. Though through the threat of impeachment, there were also concerns about the expediency of pardoning and how essential timing in cases in treason. The farmers were concerned about the inefficiency of Congress in decision-making.
Presidents who abuse the pardon power should be impeached and prosecuted, not in the criminal courts, but in the political court of the U.S. Senate. While not considered one of the most important powers, the abuse of it can have large effects. Using the power for personal or political gain, such as granting reprieves to friends or family, is an example of the president exceeding the constitutional limits. The Constitution makes it clear that impeachment is only for offenses against the United States.
Former President Trump granted pardons and commuted sentences of his associates. In doing so, he undermined the power and created an unfair abuse of power. According to a study by the Washington Post, almost a third of those who received clemency from Trump had a personal connection to him. Stephen Bannon, Trump's former chief strategist, was one of the last pardons given by Trump. The abuse of executive clemency creates an unjust government that favors those who are connected to the president. They who abuse the pardon should be prosecuted because that abuse is an impeachable offense.
High crimes and misdemeanors includes the abuse of the pardon power and therefore is subject to impeachment. Article 2 explains that the president shall be removed from office on impeachment for and conviction of high crimes and misdemeanors. The phrase high crimes and misdemeanors is not clarified or explained further in depth, therefore allowing for different interpretations of what it constitutes. As Hamilton explained in Federalist 65, he interpreted them as the abuse or violation of some public trust.
By abusing the pardon for personal gain, the president puts themselves above the law and at an advantage because they abuse the trust of the American people. The abuse of the pardon violates republicanism because the president is an elected official whose duty is to promote the common good and protect the rights of the people.
The pardon power is one that is often associated with the impeachment of presidents. When the power is abused and used for personal gain, we see how the impeachment power is used to correct it. It is a high crime and misdemeanor, meaning that the abuse of the power should result in impeachment.
The framers created the Constitution so the branches would be able to check and limit each other to prevent the abuse of powers. We see this with impeachment being used to limit the pardon power, as well as the pardon checking the judiciary. Therefore, it is clear why the framers created these checks and balances in the ways that they did, as it creates a very strong and unique form of government. Thank you. We are now ready for your questions.
So you note in your statement, and thank you for your statement, I thought it was very helpful. You note in your statement that it's easier to limit the powers of one man, citing Hamilton. And you also note the unjust exercise of certain pardons in the last administration. That suggests to me the following question. Should the president's pardon power be limited? And if so, how?
Yeah, I do think that the president's power to pardon should be limited. And I think, as we mentioned in our paper too, the president, by pardoning, if the president uses his pardon power for political or personal gain, I think that should be limited because I think he should be using his pardon for the better good of the greater good of the community and not for himself. And I think by the president pardoning people who are connected to him personally, I think that kind of defeats the purpose of the pardon power and the use of it.
I also kind of think, in addition to that the timing of these pardons should be limited as well, just based on the fact that if there's no limitations as to when these pardons can take place, most presidents, like we saw with President Trump, will dish out a lot of pardons towards the end of their time in office, and that is, they don't feel that there's not going to be any repercussions for that because they can do that and then not have any backlash.
So I would like to pursue this a little bit and ask, how would you limit that pardon, the pardon power? I mean, what institutional or structural changes would you make or recommend to limit the ability of the president to pardon?
Well, similarly, how Congress can override the president's veto, I think they should be able to do the same for the pardon. So maybe like a supermajority, like 2/3, could be used in case a majority of Congress believes that the pardon isn't constitutional and is only for the personal or political gain of the president, then they should be able to check it in the way of overriding it and saying, no, you can't pardon this person, or something along those lines.
Okay,
Yeah.
Oh, sorry, go ahead.
Oh, no, go ahead.
So the pardon would not be effective for the person who'd received the pardon?
Yeah.
Yeah.
That's what I meant.
Okay, what should we do in situations where people have been prosecuted because they are friends of the president?
Well, I think that brings up a really good point, is that it's like the connections, and there's almost like another layer of this insider like connection between the president and the person. So it's interesting to think about how, like, maybe was that person doing something for the president? So for example, in Watergate, how like the president wanted the people to like the people who committed the crimes, who broke in and actually did like the actual crime. So it's like the president was like kind of abused his power as president and made these people do it. So then it's like, should they be because of that connection, that there should be another level of prosecution.
Gotcha. You want to jump in, Anne?
Yeah, I'm having some technical issues. I so apologize. Hopefully you can hear me. Yes?
Yeah.
Awesome. So my question is, do you think the framers intended to allow the president to pardon himself or herself?
Well, I certainly think that in cases where Hamilton wrote in one of the Federalist Papers that the use of the pardon intended by the framers was to prevent a gross miscarriage of justice. And I think that when the president is sort of a biased party, say they thought they had a gross miscarriage of justice, they themselves would not be the most partial person to rule that. And I think that as the framers intended in the Constitution, if you look at it from an originalist perspective, I think that they did not intend for this to be used, and that's what I think.
Yeah, not to sorry, interrupt, but I was just gonna say that I agree, and that the pardon power should not be used to self-pardon, because the Constitution says that the president has the power to grant reprieves or pardons. So I believe that by the use of grant, and if you look at, like Walter was saying about an originalist and like giving each specific word a definition, you could look at grant and think, so they must grant it by giving it to someone else. So I don't think that they should have the ability to pardon themselves.
So would a self-pardon necessarily trigger an impeachment?
Well, I would think that it's for the Senate to judge, but I think that, or I would say Congress, I would say that if you look at it from the original's perspective, I think that it would, because it would be a misuse of the power to pardon yourself.
Yeah, I agree with that. And I think by the president using his power of pardon for personal gain, which would be pardoning himself, I think that would be a good case for an impeachment, because I think that isn't how the power was originally intended to be used. And I think if the president goes beyond that and abuses the power, I think that could be constituted as a high crime misdemeanor.
How about pardoning friends and family? Should that automatically trigger impeachment?
Well, as we saw with the pardon of Stephen Bannon by Donald Trump, we could see that he was convicted of, I believe, embezzlement, and I think that in that case, again, former President Trump was not the most partial jury for his friend Stephen Bannon, and so I think that would constitute, again, an abuse of the impeachment or the pardon power, and would therefore be subject to impeachment by Congress.
Yeah, and going off of that, Trump also could have pardoned Stephen Bannon because he was worried that something that would incriminate President Trump would come out in trial. So it brings up the question is, did he really think that Stephen Bannon should be pardoned? Or is it that Trump had secrets that he didn't want to get out that could be exposed in the potential trial of Stephen Bannon?
Why do you think the judiciary was largely excluded, actually almost entirely excluded from the impeachment procedure by the framers? I mean, the only real involvement of the judiciary is that the Chief Justice presides in the Senate. But why was that done?
Well, I was going to say is that there's actually other checks on the judiciary, so that impeachment and isn't as necessary for the judiciary, because by the president having to nominate a judge, they use their best judgment to think, okay, this will be a good judge for the Supreme Court. They will uphold the Constitution. And then Congress is another check on that by approving or not approving them. So I think that there's other forms of checks that impeachment doesn't need to be used as often, but also that does bring up the point is that some judges, more not the Supreme Court, but for the district courts, and actually Samuel Chase, who was an associate judge, For the Supreme Court, he was impeached. Although he wasn't acquitted, there has been some examples of impeachment on the Supreme Court.
So what should it take to impeach a judge?
I would say that, again, a 2/3 majority in Congress would definitely show a majority of the Senate agrees that they think that this person is guilty. So I would say a 2/3 majority in Congress.
All right, very good. Your time has expired. Thank you very much.
Thank you.
Thank you.
Very much enjoyed the conversation this morning, this afternoon, I should say. Well, it's morning here in Minnesota. And anyway, it was a great opportunity to talk about these issues. I noted that your statement makes a reference that to Hamilton, that it's easier to limit the powers of one man, and that prompted me to ask the question about whether or not the pardon power should be restricted. And you gave a great answer about a way, a constitutional amendment that could be used. I suppose it introduces the question of whether or not there are any less than constitutional amendment kinds of things that it would take to get that done. But I thought it was a great answer, and I enjoyed the conversation. I'm not sure we fully connected on this question of why the judiciary was excluded from the impeachment by the framers, but you clearly understand the impeachment power, and it was a good conversation. Anne, I think it's up to you next.
Okay, I also enjoyed the conversation. I'm so sorry that my video is not cooperating, but I'm smiling, and I appreciated the hard work that you put into this, and I learned a lot. So thank you very much.
Thank you.
Good conversation. Your opening was solid. Part of what's difficult about this question is the pardon power is a tough power, and it's pretty discretionary. Impeachment is discretionary as well. So the idea that we would go directly from the president's use of discretion to disciplining the president because of that use of discretion in a discretionary way, it gets kind of messy. It gives you all a lot of opportunities to think about how you want the particular powers to be structured, but it doesn't give you a whole lot in terms of how you should do it. So led to a good conversation, and one that we certainly appreciated. So thank you all very much, and good luck.
Thank you.
Thank you.
Much.
All right. Thank you, judges. Students, you're welcome to hang out here for just a minute. Judges, if you could click on breakout room.